You've already agreed to 10 years. No negotiations, no whatever. This is it. You violate, you're getting the 10 years that you agreed to way back when. Do you understand? Now, the misdemeanor is something that, remind me, why do I have that on?
He was supposed to have pled to his misdemeanor several resets
Right.
each time prior to coming down here, because our plan is to have him, we had talked about
To extend probation and ISF.
But now it's for safety if the court considers based on this update PSI, but obviously we can't do that until he pleads to this.
Well, I can do that today and he can go into custody and y'all can go take care of it.
That's what I was just going to.
Because he'll sit in custody until he goes and takes care of that other case, because he won't go. All right. So in cause number 16-24485, first year James Lofton. Mr. Lofton was previously in court, and that is a motion to revoke probation. On probation for the third-degree felony of assault, family violence. It was a 5-year deferred at one point, and then in February of 2020, that probation was revoked and given a 10-year term that was probated for 5 years, so went to a straight probation, placed on high medium caseload and zero tolerance. I've received the updated pre-sentence report also. Has everyone had an opportunity to review that report?
Yes, ma'am.
I have her.
Any additions or corrections to that?
No, ma'am, the only thing I would say is since PSI is that we have, this last week, we have gone and taken a drug test of Beaumont Occupational, my client has, is that, and I have those drug test results at the court within.
That's not going to change what I do based on the nature of that examination and the substance abuse evaluation. I'm going to follow those. I appreciate that he stayed clean for some amount of time.
Yes, ma'am.
But if I'm going to follow after what I just said with regard to the nature of where we've gone on this, he looks like there's a new misdemeanor, driving while intoxicated, second, and that was from December of 2023. We're just finally getting here, so I'm going to do what's necessary, I think, if I'm going to leave him on probation to keep everybody safe.
Like I said earlier, Mr. Barrington and I had previously discussed after we both reviewed the PSI that safety may very well be.
That's what it appears from that evaluation. And so I mean, I rely on them and their evaluation to say what's best and do it. And then they're talking about the not just the regular safe P, but special needs safe P, so that it covers everything from mental health to drug treatment to everything else that would be necessary, hopefully, for Mr. Lofton to finally be able to complete this probation. In addition, I will have to, and not just have to, but I will need to extend and plan on extending that probation period as well, because it's up either already or this year, and it's only pending because of the motion. Is that right?
Yes.
Okay. All right. So anything else with regard to that updated report or with me going forward with sentencing?
No, ma'am, other than the fact that he is working, I have his employer here. If you'd like to hear from them, we would ask that the recommendation initially was ISF, and we would ask the court to consider ISF and sentencing instead, because he has been working with stable employment with his employer for more than 1.5 years now, has had stable housing as far as that goes, and so we feel like that him going to safety would cause financially devastating for him. And so we would ask that he be allowed to go to ISF and then have more strict monitoring on weekly reporting and weekly drug tests with zero reporting.
Ms. Malfino?
I defer to the court's discretion here, but just my review of the PSI. I think safety is probably convenient.
And so with regard to Ms. Jefferson, you initially also agreed that ISF with being on the high-risk caseload after would be appropriate. Is that what are your thoughts?
Yes, that was my initial recommendation. But I also included that I don't know much about his case because he had absconded for, I believe, over 2 years.
Yeah. And it looks like there was tested positive for methamphetamine August 14th last month, denied using it, but stated he had used a month ago, but tested positive for it. So I'm trying to see what specifically, why special needs.
I don't believe there was any sort of psychiatric.
I didn't see that either, so I'm not real sure.
That was kind of what, the only question I had about it was.
I don't think we need-
Special needs is generally
It is, if there's
more
some
of a
type,
psychological type situation.
we don't have that, so it's just regular. Okay, so here's what I'm going to do. Mr. Lofton, I am going to find that you entered your pleas of true to counts 1 and 2 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation. However, I am going to continue you on probation. I'm going to extend your probation period for 3 years. I'm going to order as a condition of your probation that you enter and successfully complete the SafeP program, not the special needs, but the regular SafeP program. And that you'll be on the high medium caseload when you get out. You'll be required to do aftercare. I don't know how to stress strongly enough that this is your last chance. You will not, if you are back in here, I'm going to look at this paper and I'm going to wonder what I did and why. So you will be required to have a drug patch on at all times when you get out. If there's one positive, you're back in here and looking at that 10-year term. Yes.
Judge, the only question I have is, I think he was put on probation in 2016, wasn't he? Is that, can we extend for 3 years?
Well, he was put on a deferred in 2016,
Okay.
and then he was revoked and given a straight probation in
Okay.
2020. So
All
actually, I could extend him for 5 more years
Got it.
instead of just 3.
Got it. Fair enough, John. Thank you.
I'm going to hand you the trial court certification. I need y'all's signature on that, showing that this was an agreement that I followed, and so you've waived your right to appeal. You'll go into custody. Obviously, Mr. Barrington will get it set up as quickly as possible for you to go take care of that other case down the hall in misdemeanor court, because until that's taken care of, you will not be able to go to safety. So y'all need to get that taken care of as quickly as you can.
Yes, sir. Yes, sir.
Thank you for being here. Thank y'all.
May we step over here, Your Honor?
Y'all just sign it real quick right here and they'll take them back. Thanks, Mr. Barrington.
Where's the sign on this? We're just right here where it says defendant.
Mm-hmm. Here, I'll give you the, hold up, sec. Here, the copy for you.
Thank you.
Thank you, sir.
Thank you.
Mr. Burbank, you've got Renisha Chase on.
Yeah, my paperwork with that.
I have one of them.
Yeah, the other one's an MPRP. I'll put it
He has 2 cases.
Mm-hmm.
One of them that he's saying is an NTRP, they didn't do paperwork on, but the other one's in the case.
Just our intention, if the court would allow, is to have her enter the plea, do a PSI, to kind of see where she is now. This was a case we brought over from CDC, and then decide what is best on the motion. Either to
The burglary that I have is the MTRP.
Yes, ma'am.
Okay, for some reason I said, before we go any further, I've got a note to remind myself, I have a seat in the jury box. I'm going to get a drug test first. Hang on to it because it'll get mixed up with my other stuff. Please and thank you. Thank you. You don't want it to get lost in the abyss that I have going on up here. Ms. Coffin, you have Zachary Turner.
Yes,
Good morning.
Good morning, Your Honor.
Morning, Mr. Coleman. Good morning, sir. You're Zachary Turner. And this is 24 DCCR 2197. Mr. Turner's charged with fraudulent use or possession of identifying information. And what is the announcement?
Your Honor, we're needing a reset. I've talked to the prosecutor and we're needing some more evidence.
There appears to be maybe some videos that did not make it to our file,
Okay,
and thereby not turned over to the defense counsel. So I'd like some time to run it.
sure. All right, so I'll just do a normal reset. Mr. Turner, make sure you stay in touch with Ms. Coffin. Once she gets that information from Mr. Coleman, you guys can meet and go over it, and then we'll see if we can get an announcement at the next court date. All right, thank you. You're free to go. Thanks, Ms.
Thank you, Your
Coffin.
Honor.
Let's see, is Mr. Cole here? Mr. Leish? On Carly.
This bond condition is significant. Taking away someone's driving privileges before trial isn't about punishment. It's about preventing another potential tragedy. The court's priority here is reducing risk while the criminal case moves forward.
Judge, this has been the one with federal
Yes.
issues,
Mhm.
and we had a proper meeting with the feds in early September, late August, for a day. I had informed them that this needed to be wrapped up because of what you had expressed to me in our last meeting. They have followed up with me and said that charges are imminent. And Judge, just to be very straight with you about it, they had told me that in June. And then I'd said, I'm getting heat respectfully from the courts. And she has charges also pending in chambers in Hardin County. The courts are aware of what's going on. Mr. Moran, the assistant U.S. attorney, informed me that he thinks it's going to happen. He alluded to me it's going to be in October, but I have no way of telling the court with absolute certainty that's correct. So I don't have control over it because I thought it would be sooner.
Right.
But the dilemma for me is, and Mr. Smith, who's been super helpful and accommodating dealing with this issue, is that we know that the federal charges are coming. They haven't landed yet. But I don't want to be placed in a situation where I have to clean state charges and the federal charges are coming. That's why I brought that email.
I appreciate the email. If you don't mind, I'm going to hang on to this.
Absolutely.
I might give Ray a quick email or a call just to find, I've known him we used to work together, so I'm fine with.
I've spoken with him, I've sent him all of the restitution amounts for other cases.
Yeah, and he may be waiting on other.
We had like a 6-hour proffer meeting with the U.S. Attorney's Office. We have nothing else to give them.
Right.
We give them everything and he's fitting. It's really just waiting for, he's claiming a debriefing and the charge is coming, but it's taking
Okay.
quite time.
Sometimes justice moves slower than everyone wants, with possible federal charges still pending. The judge is choosing patience over rushing a decision. Would you wait for every piece of evidence or move forward immediately?
Going to do, let's do 45 days, reset, and then I'll email him or give him a call and just see if he can, if maybe that helps, or at least I can find out if they're waiting on maybe other agencies that y'all don't have any, or you don't have any access to, if there's other counties involved.
The first email that's on here, you might notice that I was getting a feed from Jefferson County, but it's Judge West.
No, I saw, I saw that. No, I'll give him a call and see if I can get some more information, and then we'll hopefully get some answer between
If
now
I
and
know
then.
anything, I'll come.
Okay, thank you. All right, you're free to go. 45 days. Thank you, Mr. Rennick. Mr. Wilson, Mr. Wilkerson, Mr. Cole, Mr. Adams. See, Mr. Cole, you have Leonard Idleberg.
Yes, sir.
Oh, that's okay. I think it might help just to others to know what's going on too. Would you put a sticky on that and then put it on my desk just to remind me to do something with it, please, ma'am? Good morning, Mr. Cole.
Good morning, y'all.
Good. Good morning, sir. Are you Leonard Idleberg?
Yes.
This is cause number 16-25968. It's the MTRP. I feel like we're waiting on, there was a motion for a competency evaluation,
Yes, ma'am. He found the
but I don't see that it's been done yet.
It's been done.
It has, we just
Yes.
don't have a report yet.
It should have been e-filed into the case, Your Honor.
The report,
Yes, Your
they
Honor.
sent it to you?
Yes, Your Honor.
I
Oh,
mean, not to you.
oh,
I mean,
okay.
I certainly take
Who
Mr.
did
Cole's
it?
word for it, but
Dr. Riggins out of Houston.
Oh,
The court wouldn't pay for his evaluation.
I don't see that it's in here yet.
I do have a copy of it.
Can I see it real quick?
I'll have to send it to your email, Your Honor.
Oh, okay.
Yes.
All this paperless stuff.
Yes, Your Honor.
Finding competent, not competent?
Not competent.
Okay.
not competent or
Dementia.
dementia?
Dementia.
Because I think there's a legal difference.
Yes.
Yes.
Yes, it was dementia.
Okay. Obviously, we need to take a look at that. I'm going to reset it 2 weeks.
That sounds great.
If you will make sure, it should, if you e-filed it, it should be coming through. But if you'll also just in an email forward that report to Ms. Malfino and
Yes.
and that way you guys can take a look at it, talk and see if there's something that you can work out. I can look at what my options are with regard to that diagnosis, and then we'll see where we are in 2 weeks.
And Judge, just so the court is aware, I spoke at length with his probation officer, Ms. Hunter, last week. Previously, when we were here, I believe back in June, you ordered that he not drive, and you spoke with his wife here in court.
Yes, yeah.
Ms. Hunter relays that he is complying with all that. She
Okay.
actually comes to his appointments
Good.
with him, and that everything seems to be
Okay.
going well with respect to that condition.
Okay. Well, maybe we'll be able to work it out with just modified type probation. We'll see. Okay. All right. We'll see you in a couple of weeks. Mr. Gertz, you've got David Hatcher. Morning.
Judge, how are you?
Good. How about you?
Well, I'm good. Excited about this week.
Oh, me
Aren't you
too.
excited?
I'm so
I can
excited.
see it all over your face.
Good morning. You're David Hatcher.
Yes, ma'am.
And this is 24 DCCR 2470. I have a memo that this was the last reset for an announcement.
There's a rejection I just forwarded on, Your Honor. And it's pretty non-specific. Any offer that was going to be made is going to be a pen time offer.
Okay. Let me get that.
We were looking for something vastly different than that, so.
All right, so you're David Hatcher.
Today's docket showed every side of the justice system. Second chances, strict warnings, delayed decisions, and cases headed for trial. Through it all, one message stood out. Every choice inside and outside the courtroom can shape a person's future.
And Mr. Hatcher, you're charged with a third-degree felony offense of intoxication, assault with a vehicle causing serious bodily injury from September 24th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment could be between 2 years and up to 10 years in prison. Do you understand?
Yes.
And I have a plea bargain rejection that you've signed with Mr. Gertz that just shows that any offer the state would make would be for prison time and not for a probation. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Right? Anything that you guys are waiting on discovery-wise?
Nothing I know of.
I'm not aware of anything discovery-wise, Judge.
All right, we will get it set on the next available trial docket. Stay in touch with Mr. Gertz. He'll let you know when you need to be back. Thank you. You're free to go. And Christopher Thomas, Mr. Gertz.
We'll meet Ashley back for that.
Did she step out? Did Ash, which way did she go?
This is important, so.
Just have a seat for a second. I'll recall it in just a second.
Thanks, Judge. Sorry.
Mr. Kelly, you've got Donald Owens.
He's present.
Good morning. You're Donald Owens. And this is 24 DCCR 1192. Mr. Owens is charged with sexual assault of a child, set for trial to begin with jury selection next Monday. And what is the announcement?
We're still, stay to it.
All right, then I want to make sure that y'all all understand, obviously after today, no plea agreements unless there is something that comes up very quickly that I'm not or y'all aren't aware of. It is likely to be towards the top of the list since the other old one is gone now. So stay in touch with Mr. Kelly. He'll let you know when you need to be back next week. Okay? All right, you're free to go.
Thank you, Judge.
Thank you. See, Mr. Lewis, you have Naquindon, oh,
He's right here.
there you are. Naquindon Acklese.
Yes, Judge.
Good morning, you're Naquindon Acklese.
Judge, you're going to ask me this in sentence, I'm going to explain now. The reason it's now a probation offer instead of a 10-time offer, which originally was based on his criminal history, because he had done a 10-year stretch for robbery, starting in 2014. Really, I'm rewarding him because he's tested clean every time since about this time last year, Your Honor. And he's come to court. He's done what the court's asked him to do as far as trying to hire an attorney. I think he ended up still having Mr. Lewis appointed, but I know that he's done everything the court's asked him. Essentially, I'm rewarding him because he's tested clean ever since September of last year.
Okay, thank you. And your signature. And are we going on count one only?
Yes, Your Honor.
Okay, you're Naquindon Acklese,
Yes, ma'am.
and will he waive the formal reading of the indictment?
He does, Judge.
Mr. Acklese, in cause number 24, DCCR 0478, the state has elected to proceed on count one only. It alleges you committed the second-degree felony offense of burglary of a habitation from February 5th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up, please.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before
Rejecting a plea offer is one of the biggest decisions a defendant can make. By choosing trial, the outcome shifts from negotiation to a jury's verdict where the penalties and the uncertainty can be much greater.